This happened in 2023 for a grand total of $66,000. My office was successful in sending 2 of them to prison for 5-year terms, and the other defendant, Miss Aranda, received a 2.5-year prison sentence for her crimes. They each pled guilty to multiple counts of organized crime, or organized retail crime. I bring this to your attention as an example because just 2 weeks ago, I stood with Chief Michael Sullivan of the Phoenix PD and announced another significant case where nearly $600,000 worth of merchandise was recovered from makeshift makeup stores that were actually in people's houses. 3 women in that case have been indicted. The very next day after that announcement, a bill that we had been working with the legislature on, Senate Bill 1414, which had made its way up to the governor's office, was vetoed by the governor. Senate Bill 1414 would have been an important tool for us in the prosecution of these types of cases, and they would have brought longer sentences for people who are committing repeat offenses or spree offenses where they're not caught after the first one or two offenses. Instead, the governor signed a bill that set up a task force to look into organized retail crime. Well, at the Maricopa County Attorney's Office, we don't need a task force because we have a task force and we've had one. And we know what's going on the ground because we deal with it every single day. We are in constant contact with the police departments throughout the valley so that we know what they're facing. And we are in constant contact with retailers who are telling us what they are seeing on the ground. So I found the veto of 1414 odd and frankly very disappointing. But I want to be very clear here. We still have tools to make sure that people who commit organized retail crimes are held accountable. As you can see, without that bill, we were still able to send these 3 women to prison for 2.5 years on the one case and 5 years on the other 2 cases. So for people who think that this is going to be another Los Angeles where the DA there, George Gascon, has made an announcement that he's not going to prosecute certain cases, you need to think again. This is Maricopa County. We will hold you accountable. Another important announcement. Earlier this week, 2 of our sex crimes prosecutors obtained a guilty verdict in a case that involved the sexual abuse of 5 children that were known to the offender. Now that he is convicted, and there were 13 counts, Gerardo Mendez Estrada of Phoenix will now face multiple life sentences when he is sentenced later this summer. And with that, I will, we have his picture up here, but with that, I will open it up for questions.
Hi, Rachel.
Hi. Hi, Brian.
A couple questions, if you don't mind.
Sure.
Can you go through the arrest of the protesters at ASU? They consider that lawful, peaceful protest. What's your take on that?
You know, at this point, we have not received any submittals from ASU for those cases. So no one from this office has had a chance to review the full reports. My understanding is that they arrested 72 individuals between Friday and Saturday, maybe into Sunday. There was probable cause found by the courts on 69 of those. And as soon as we get the submittals, obviously we'll have more information so that we can really address that.
Last one, I've been asked to ask you, are you considering charges for the adults who held the house party where Preston Lord was killed?
Those cases were, or those 2 individuals were submitted to us, and that is under review still. Hey.
Nicole with ABC 15. Our station had a question about Roderick Roberts. This is the man who I guess is accused of operating as a pimp and committing ag assault with a deadly weapon and he's
Yes.
in jail. Okay. It looks like he was out on probation for about a year after a murder conviction in Washington State before reoffending here in Arizona. Did the probation system work correctly in this case, and what steps can the county attorney take to make sure Roberts can't reoffend again?
Yeah, so you're correct. He was prosecuted out of Washington State. I'm not sure if he was on probation or parole, but he was on some sort of supervision following being convicted there. Then he came here, and we have indicted him on April the 25th of the following charges: aggravated assault, class 3 dangerous felony, 2 counts of sex trafficking, which is class 2 felony, and then 1 count of misconduct involving weapons, a class 4 felony. So that would be somebody who is a felon in possession of a gun. And Nicole, you've been coming to these. You know how often I talk about that is basically a harbinger of things to come when somebody is in possession of a weapon who is a felon. So to answer the question, did the probation or maybe parole system work? Obviously not, because he committed new offenses. And what steps can the county attorney make to make sure? See, you have me referring to myself in the third party. That's kind of weird. What steps can we as an office take to make sure Roberts can't reoffend again? Well, we can make sure that he doesn't get out of custody. He is on a $100,000 secured appearance bond right now. Obviously, these offenses are very serious, and they call for prison mandatory sentences. That said, people are presumed innocent until proven guilty in a court of law. But I think that goes to a bigger question of probation, supervision issues, and more to come on that in the upcoming weeks. But there's been a lot of talk in recent years about reducing incarceration, prison time. But what I would say is the county attorney is, give me an alternative that works. Give me one that can guarantee that this person is going to be supervised or monitored to such a degree that they can be in the community safely, because that didn't happen here. And when that doesn't happen, then it leaves little alternative for whatever prosecutor if their primary responsibility is to make sure that people stay safe. So those are some things that we can do. Obviously, incarceration at this point, or keeping them in pending trial, but that is something that needs to be looked at, is the efficacy of probation systems across the country. One of the things I would point out is about 10 or 12 years ago, we shifted in how we measure that. And we used to measure whether probation was successful by, once they were off probation, did they reoffend? And I think that's the best way to do it. But at some point we shifted to what now we measure it as, do they get off probation without being revoked to prison? Which of course creates interesting incentives about not revoking people. So anyway, more to come, but those are some initial thoughts.
Okay, thank you. And then shifting to the Gilbert Goons, right now we're at the press conference with Gilbert Police, where they're expected to talk about with their investigation back. I don't know what's happening right now, but okay. I do have a question as far as we've heard from victims.
I'm sorry, a DVR wouldn't work here.
Yeah. Press conferences. We've heard from victims' families this week that they've been told by people who work within the county attorney's office that the Gilbert Goons have been documented as a group for years. So can you tell us what that means and how long they've been documented?
I'm not sure what they mean by documented as a group. There is a process through the Department of Public Safety to recognize, I would use the term recognize, a group as a street gang. That hasn't been the case for years. But that said, let me go back to some of the things that we've talked about in the past. Number one, even if a group is recognized as a gang, that's just one step in the process. You have to have a recognized gang, and then you have to have an act that's either assisting that gang or an act in furtherance of the goals of that gang. So it's not just whether there's a gang and whether somebody is a member of it. You have to have all of those things. But I don't have information that they have been a recognized gang under the formal process prior to this year.
Okay, so if Gilbert announces today would charges be added to the Preston Lord murder case and or the other teen violence cases if the Gilbert Goons are classified as a street gang?
Two things on that. One is when we presented the Preston Lord case to the grand jury, we presented a full and thorough presentation of the information we had, including information that you would go toward your question. The charges that they handed down are the charges that they handed down after hearing all of that. That said, if additional information becomes available, we do have the ability to go back and file enhancements. And with any case that comes into this office, we're certainly willing to look at additional information and determine whether we should go back for more charges or whether we should file enhancements. And we're open to doing that in this case as well.
Okay. So your office did not have anything that they were a street gang for years?
I don't have any information that they were a recognized street gang prior to this year. Yes.
Hey, so speaking of that press conference,
Okay.
There's a reporter. Yes, I do. So apparently they have declared the Goons are a gang, but they will not submit requests for gang charges in any of the cases.
Okay.
Could that information then be used at sentencing, or how might that affect your case going forward?
Well, obviously, we're going to take all of it into account, both in, the charges that we have, any charges that might be submitted in the future, but certainly at sentencing. But again, let me go back to just having the name Gilbert Goons associated with a criminal street gang does not mean that a particular crime was committed to either assist that gang or in furtherance of that gang's goals. And so we'd have to look at all of that. And we would. I mean, we definitely, as information is being developed, we're looking at it as it comes in the door, for sure.
Okay, and I guess that they had said that they are classified as a hybrid gang. What does that mean?
I'm going to speculate a little bit here about their meaning. Excuse me. What I would say about this group of individuals is, I think it's probably what everybody was struggling with when the questions were initially coming down, is this a gang? Is they don't look like a traditional gang. And, I think we all have in our minds, probably somewhat from TV, what gangs look like and how they operate. And this looks a little bit different. And so whether they're referring to that or something else, I don't know, but that would be my speculation.
And on another subject, there's been a recent push under new leadership from the Governor's Office of Highway Safety regarding drug recognition experts and getting more officers and more departments trained. I'm wondering what your experience has been with these DREs and if they've been helpful in cases and, if there's any better chance of a conviction that you found when they're involved in cases.
Yeah, actually, my first assignment in the county attorney's office when I was a law student intern was with the vehicular crimes unit. So I've been familiar with the DRE program for, I'll just say, a long, long time. And they're invaluable because basically we have a very, very sound training program here in Arizona. But it not only teaches them to identify signs and symptoms of particular drug usage, but a lot of times people use multiple drugs that have sometimes synergistic effects, sometimes they impact each other in opposite ways, and kind of sorting that out. So that's very valuable, but it's also incredibly valuable in determining whether there's impairment. And let me give you the exact example of that. So once legalization of marijuana occurred in Arizona, that shifted how DUIs could be prosecuted. So when marijuana was illegal, having marijuana in your system and driving was illegal. But now that it's legal, you have to have it in your system and be impaired. So one of the best ways to determine impairment is to use a drug recognition expert who evaluates the driver to see if there's signs and symptoms of impairment. So in those situations, it's critical. And I can tell you from the time that I started in this office, when I mean, anecdotally, I'd say maybe 10% of DUI cases that I saw were drug related. It's now pretty close to 50-50 drug alcohol. And so this is a vital program.
In speaking to some defense attorneys that handle these cases, they said, there's no set test for marijuana specifically, if somebody's driving under the influence. And so they kind of question some of the science behind this. What would your response be?
Well, I think they're kind of mixing their metaphors there, because what they're saying is there's no set standard like alcohol. So like in alcohol, we have the 0.08 where we can say everybody is impaired at a 0.08, and you don't have that equivalent standard for marijuana. And in fact, the initiative that was passed by the voters says in there that you really can't just set some sort of random standard. You have to have agreement within the scientific community, or words to that effect. So you have to show impairment. So to say that I don't believe in the science of the DREs because you can't set a standard, that's mixing things up. You can't set a standard. That's why you need the DREs to show impairment.
Would you support, some states use a set standard for THC in the system. Is that something that you think would help here in Arizona if that were implemented?
I think it would help, but I don't think it can be implemented under the initiative that was passed, as you know. But unfortunately, a lot of voters don't know, is once a voter initiative is passed, it becomes very, very difficult, if not impossible, for the legislature to tweak it, amend it, maybe fix up the language at all. And so that's going to be very hard to do with marijuana in Arizona. But yes, I mean, if it were possible, I would support it.
Thank you.
Hey, Jimmy.
So as more potential protester prosecutions loom, we talked about how you said there's 69 probable cause. Is that what you said?
I believe that's, 69 of 72.
Safe to assume that you're going to be faced with some decisions here soon. Can you talk about
It's safe to assume that every day of my life.
I'm sure you wake up every day.
Okay.
A lot of decisions. So with respect to this, what lessons did this office learn from the previous instance of charging protesters and then having to drop those charges that you'll be applying as you kind of wade into this territory again?
Well, I mean, certainly one of the things that needs to happen is there needs to be immediate higher up involvement in reviewing the cases for charges, and that there's going to be that, and that's why I've already been briefed on what's going on. Obviously, we don't have the final reports, so that makes a big difference. We're also going to look at specificity. I mean, that's really the key here. You can't lump people together. You have to show that a particular individual committed particular acts that constitute a crime. And so those are two things that come to my mind as far as things that I have to monitor in any kind of case like this.
Do you have people on staff that are, have special expertise when you're considering constitutional speech matters like this? I mean, are there people that you go to specifically, or?
We have people that are very well versed in requirements under this type of prosecution, and we're very aware of it. So yes, and plus we have a civil department as well that can advise us.
Okay, thank you.
Mm-hmm.
Good afternoon, County Attorney Mitchell. John
afternoon.
Call, 12 News. 13 days ago, nearly 2 weeks ago, there was a 17-year-old girl from Mesa attending Westwood High School who was arrested after she says that she was bullied on campus and spent 12 days in the juvenile detention center. She was finally released yesterday. We wanted to see if your office, A, has been made aware of this case. B, are you guys currently looking at it, the charges that have been filed, and just what information could you be able to give to this family of this 17-year-old girl as she's facing these serious consequences right now for an incident that she says that she was simply trying to protect herself?
Well, I'm going to tread lightly here because this is a juvenile matter, but I do know that the family has been interviewed on TV. Yes, I am aware of it. The office is aware of it. We were made aware that of her statements that this was acting in response to some bullying and some other activities. But what the public also needs to be aware of is that there were very concerning statements made by this juvenile and concerning actions taken by this juvenile. All of that to say, not that she's guilty, but all of that to say that we need to make sure that we have a full and complete picture before we proceed on, anything permanent on a record, and we're trying to get that information now. It's not only critical that her rights are, upheld, but it's also important. It's incumbent upon me to make sure that because of statements that she has made, that other people at the school are safe, and so we're looking at all of it.
Thank you.
Stephen.
County Attorney, I wanted to ask you something about the statement you made in regards to the 1864 law you had made, which is going to be repealed, or I don't know if it's been signed, the repeal has been signed yet or not. Oh, okay, well then it's been repealed. But at that time you said that your office would not prosecute abortions for rape, incest, or molestation, I think is what you said. So if the 15, I don't know if 15-week abortion ban is in play now, but if it does, if that's what is the law, there are no exceptions for rape or incest under that law. So how do you square the fact that you've said in the past that you would enforce the law no matter what, and the fact that you say that you will not take certain cases if they involve rape, incest, etc.?
Well, what I would refer you back to is, I made a pretty all-encompassing statement several weeks ago, but what I would say is this. My understanding, my reading of the law is that no exceptions are required up into 15 weeks. So, in essence, there are exceptions.
Well, we're talking about after 15 weeks. Would you prosecute after 15 weeks in case of incest or rape?
I would refer you back to my statement about I will follow the law. There's no way that I'm going to stand up here and tell people to violate the law that is in effect. But what I would say is the concerns that I have as a prosecutor who has prosecuted sex crimes cases are those types of situations. And I think those exceptions do, in effect, exist now that the governor has signed this bill. So
I don't see how they would exist under the 15-week law. There's no exception for rape or incest. But you're making an exception for rape or incest.
and no, I think the law
So-
doesn't require an exception.
So after 15 weeks, if you were brought a case of an abortion,
I'm not going to issue an advisory opinion.
oh come on, you do this all the time.
Actually, I don't.
Really? You don't?
Thanks, Stephen.
All right. Okay. You don't see any problem with that. You said you would follow the law, but you say you'll not prosecute for rape or incest.
I think I have been consistent. In fact, I've been dealing with this issue since 2 years ago, and I think I've been consistent. So, thanks,
Not to be
Stephen.
argumentative, but it is inconsistent.
Anything else? All right. Thanks a lot.